Hello, everyone. Thanks for joining us today. My name is Cody Cassady, and I'm the Marketing and Outreach Coordinator here at GuideStar. We are excited to have you all join us today to learn more about copyrights and trademarks and the things you need to know specifically for nonprofits. Before we begin, I wanted to take a quick moment to share some exciting news about GuideStar. As many of you may have heard, we are in the process of completely redesigning the GuideStar nonprofit profiles, which are the individual pages on our site for nonprofits. We launched the beta version of our new profiles last week and are actively collecting feedback. If you'd like to learn more or see how to view the beta profiles, I'll post a link to our blog post with all the details in the chat box on the right-hand side of your screen in just a moment, and I'll also include a link to that in the follow-up email in case you want to view later. Next, I wanted to go over a few housekeeping items for today's event. Our presenter today, Jeff Tenenbaum, has crafted a fantastic presentation utilizing the great questions you submitted in anticipation of this event, but we've also blocked off a period of time at the end of today's event to answer more of your questions. To submit a question, simply navigate to the Q&A box on the right side of your screen. Depending on your computer, it may not be showing up right now. If it isn't, simply look for the Q&A button near the top or bottom right-hand corner of your screen and select that button to activate the Q&A box. Feel free to submit questions, including any technical questions there that come up as you have them. We'll address as many as we can towards the end of the event. And lastly, don't worry if you missed a point or were unable to write down a note. We're recording today's event, and you'll receive that recording via email within a few days to watch as many times as you'd like. And with that, I'm happy to introduce Jeffrey Tenenbaum, partner and chair of the Nonprofit Organizations Practice Group at Venable LLP. Jeff, also an accomplished author, lecturer, and commentator, is one of the nation's leading experts on nonprofit legal matters. For his work, Jeff has received numerous accolades, including several years among Legal 500's leading lawyers in the not-for-profit category. We are excited to partner with Jeff today to bring you some insight on this complex area of law. So without any further ado, let's get started. Jeff, take it away.
Thank you, Cody, and good afternoon to everyone, or good morning to those of you in other time zones. We have a very interesting, very hot set of topics to cover here today. Unfortunately, we have very little time to do it. This is an area of law. I've been practicing nonprofit law, representing nonprofit organizations my whole career. And in all of the various areas of law that I work and that we in our nonprofit practice at Venable work in representing nonprofits, to me, the area of copyrights and trademarks has always been one of the most interesting. Interesting to me as a lawyer, but very complicated and often even counterintuitive to clients of ours and to individuals like yourselves who work at nonprofit organizations. This is a complex, confusing, and difficult area of law. However, one thing that I've learned about this area through the years and through a lot of very practical experience is that if you get a decent grasp on a lot of the basics in this area, which is what I'm going to try to do today, and if you take a lot of fairly simple proactive steps, some very simple and inexpensive, some a little more difficult and a little more expensive, but all very doable, this is one of those areas of law where putting in a little time and investment at the outset can really go a long way toward protecting your organization, protecting its intellectual property, and keeping it out of trouble in the intellectual property space going forward. And so hopefully you're going to walk away from today's webinar with that understanding. We have a lot of folks on the webinar today, I believe over 600 folks from around the country. We also received, I cannot even begin to count how many questions from individuals, from all of you, in advance of the program. Obviously, we're not going to be able to even come close to scratching the surface of that many specific questions, and many were very fact-specific. But the good news is that I did read through all of the questions, and I'm pretty confident that the core of the material we're going to address today will answer a lot of those questions. We are going to, for sure, leave some time at the end for Q&A. Cody will be posing those questions to me after I finish the prepared presentation. So feel free to ask your questions. I would encourage you to not make them too fact-specific, but to try to keep them on the more general and the higher end to make sure that the answers are relevant to everybody else. In addition, as we're only going to be able to cover so much here today, and there's only so much I could cram into a PowerPoint slide deck, I did provide to Cody, who provided to all of you, a number of articles of ours on these topics that we've written over the years, including a couple within the last few months, which I think are very good overview articles for today's presentation. In fact, one of them, one that we just published last month called Top 10, actually 11, Copyright and Trademark Tips for Nonprofits, was really the impetus for today's program and is a good overview of the issues we're going to be talking about here today. So I would encourage you to reference those resources, those articles that were provided. Also on the last slide of today's PowerPoint presentation, there are links to a very wide array of resources of ours on our firm's website, hundreds and hundreds of various articles and PowerPoint presentations on these topics, as well as some recorded webinars. So feel free to access those for more information. Now, let's dive in. Top copyright and trademark tips for nonprofit organizations. First off, so before we get into that, let me go back. And I probably should have started at the PowerPoint slides with this, but one thing I've always seen over the years is that there's often confusion. In fact, this is incredibly common. It's more common than the alternative. That folks that work at nonprofit organizations often do not understand the difference between copyrights and trademarks. People often get them confused. It's a if you're one of those individuals, don't feel badly. The vast majority of my clients seem to be in the exact same boat. So first off, when you hear the term intellectual property, what does that mean? Well, intellectual property is a term that covers an array of intangible property, things that you can't really pick up, intangible property that includes copyrights, trademarks, patents, and trade secrets. Those are the most common forms of intellectual property. We're not really going to be talking about patents or trade secrets today because they tend to not be as relevant for most of the activities and operations of most nonprofit organizations. We are focusing on the two most common forms, copyrights and trademarks. So what's the difference between a copyright and a trademark? Well, one way to think of it that one of my colleagues likes to refer to is that trademarks are your brand, while copyrights are your content. That may be an oversimplification, but it may be helpful to you in understanding the difference between them. So actually, let me scroll back here. If you look here on the cover slide of today's PowerPoint presentation, you see a couple logos there. You see the Venable logo and you see the GuideStar logo. Let's take the GuideStar logo. The name GuideStar and the logo is a brand identifier. It identifies the source of the services that the GuideStar organization provides. So that functions as a trademark. Technically, it's called a service mark. Trademarks identify the source of a product, whereas service marks identify the source of a service provider, and most nonprofits are deemed to be service providers. But that being said, most people refer to them generically as trademarks. So that mark there, that logo, identifies the source of those services that GuideStar provides. So it is a trademark and is protectable as a trademark. However, it's interesting in that that logo also has some kind of unique creative aspects of expression to it. A copyright is a unique expression of an idea. It's taking an idea. It could be a drawing. It could be a photograph. It could be an article. It could be a video. It certainly can be a logo. Any unique expression of idea also can be subject to copyright protection. And that GuideStar logo, including the little image that's off to the left of the GuideStar name, is protectable under copyright law as well. And so the same piece of intellectual property can function both as a trademark and a copyright. But in order to maximize its protection as both a trademark and a copyright, you're going to want to do the things that we're going to talk about in today's webinar to provide maximum protection. So with that as background, let's move on here. So the first tip for nonprofit organizations in this area is notices. And what you're going to see here, too, is that with copyrights and trademarks, some of the rules for copyrights and trademarks are very similar, and some are different. And it's important, of course, not only to understand the difference between a copyright and a trademark, but understand how some of these rules apply in one way to copyrights and in other ways to trademarks. So let's talk about both. For copyright, and in both of these instances, it's always important to use notices. A copyright notice and a trademark notice. These things put the rest of the world on notice that these are protected forms of intellectual property of your organization. And the good news is that you can use notice, copyright and trademark notices, on your intellectual property regardless of whether the intellectual property is registered with any U.S. federal agency or any state. You are allowed to and are encouraged to use, for instance, copyright notices on all creative works published by your organization, and trademark notices on all trademarks, service marks, and certification marks owned and used by your nonprofit organization. The copyright notice, as you can see on this slide, it's that little C with a circle around it, or you can spell out the word copyright. The year that the work is initially published, kind of initially released to the public, and then the name of your nonprofit organization. You also can include the words all rights reserved, but that's not essential. But basically, this puts people on notice that it's your intellectual property, it's your copyright, it's protected. It tends to be a good deterrent to copyright infringement, and it's just a good and a best practice for sure in the nonprofit community. Do you have to put it on every page of every document and every page of every website? No, you definitely don't need to. Obviously, the more that you, the more and prominently you display your notices, the better protection you're going to get from that. But at least on the front page, or if it's say a print publication on the inside editorial page, is where you would typically include a copyright notice. And irrespective of whether your copyrights are registered with the U.S. Copyright Office, which we'll talk about in a minute, you can and should use that same copyright notice. That notice has nothing to do with federal registration. Now, trademark notices, the rules are a little bit different. I strongly encourage you to use trademark notices on all of your trademarks. Again, skipping back to that cover slide here, if you look real closely next to the GuideStar name and next to the Venable name, you'll see a little R with a circle around it. You've all seen that hundreds of times on all different protected trademarks. That R with a circle is reserved for it's reserved for trademarks that are registered with the U.S. Patent and Trademark Office. That's the Federal Trademark Registration Agency. Also covers patent registrations. You can only use the R with a circle around it for federally registered trademarks. That's the only time and place that you can use the R with a circle around it. If, however, you don't have a federally registered trademark, it's not registered at all, or it's registered in a particular state in the U.S., or it's registered in other foreign countries, but it's not registered with the U.S. Patent and Trademark Office, you should still use a trademark notice, but it's going to be that little TM that you've seen as well, kind of in superscript, instead of the R with a circle around it. As I said here, while these notices are not required, and you don't jeopardize your rights by not having these notices, their effective use can significantly enhance your intellectual property rights and can eliminate what lawyers call an innocent infringement defense. You should use them prominently, consistently, and in all media. Does it mean you have to use, for instance, let's say the name of your organization is a federally registered mark. Does it mean you have to use that R with a circle around it? Every place that the name of your organization is mentioned in every publication and every website and every other form of media? No. You definitely don't have to do that. There are some organizations that do, but again, use it prominently, consistently, and in all media. Okay, let's move on here to our next tip, registration. Here we're talking about registration of trademarks and domain names. Now, as I mentioned, trademark registration is very, very, very important. Is it essential? No, it's not essential in the United States, because in the United States, it's one of the few countries in the world that has what are called common law trademark rights. And these are rights, it's kind of court-made, judge-made law that does provide protection for marks, for your names, for your logos, for your slogans that identify the source of products or services. It does provide protection. Basically, the more you use those marks, the greater the protection is under common law. And those rights are enforceable. You can file lawsuits to enforce those rights. And the idea in trademark infringement is what we're calling it, where someone else is using your mark. The key is it likely to confuse the public as to the source of that product or service? If there's a substantial likelihood of confusion by the public, by the viewer, by the reader, of who is this mark identifying, what product or service provider is this identifying, then there very well may be trademark infringement. That's kind of the basic test for trademark infringement. Jumping back to copyright, in the copyright area, the basic test is the content again, copyrights are generally about content, is it substantially similar? In both cases, it definitely does not need to be identical, far from it. And there are plenty of cases that find copyright and trademark infringement in situations where you may say, hey, that really doesn't look very similar to me, or likely to confuse the public. It's a very fact-specific determination, but those are the basic standards. Now, getting back to trademarks and trademark protection and registration, as I said, in the U.S. there are common law rights, and there are many, many, many nonprofits, including, I'm sure, many of yours, particularly smaller ones, particularly nonprofit organizations that don't have the resources to pursue federal or even state trademark registrations, that have never pursued registration. You do have rights in your marks, in your names, in your slogos, the names of your big events or programs or products or things like that. But particularly for national or organizations that operate on a national basis, I highly recommend investing the time and the resources to get federal registrations, at least of your name and your logo, and generally these are going to be, and highly advisable to be, two separate registrations. The trademark registration for the name covers the words in that name, so if someone else is using those words in any way that is likely to cause confusion amongst the public, that can cause infringement of that federal trademark registration for the name. For the logos, these are called design marks, design registrations. What you're basically getting protection for is how that is all put together, the basic overall look and feel of that design. For instance, that GuideStar logo on the front page of the PowerPoint. And that's a different sort of protection, and you could have someone that's infringing your design mark without using the same name, but in a way that has that same look and feel. And that's why we generally recommend separate registrations for the name and for the logo. But registering it with the U.S. Patent and Trademark Office is going to give you nationwide rights. It's going to make it much easier to enforce those rights. In addition, there's some additional benefits that have come about in recent years. For domain names, we're registering the names of websites and email addresses and whatnot. The kind of dispute processes that are in place for domain names can be substantially aided by federal trademark registration. Basically, if you have a federal trademark registration for your name, your organization's name, for instance, and someone else came along and registered a website basically incorporating your name or your acronym into that website, if you have federal registration, trademark registration for your organization's name and or acronym, by the way, sometimes acronyms also can be subject to separate registration, then you can use that, and it's a very important component in that domain name dispute process, and it'll make it much more likely you'll be successful in prevailing in that dispute process. I know a lot of the organizations of this webinar, based on looking through the registration list, are domestic U.S.-based organizations, but I know in our practice, and it's not any different for the rest of the nonprofit community, U.S.-based nonprofit organizations increasingly are operating overseas. That's been a very clear trend now for a number of years, and we have many, many, many clients that are very active overseas and at all different levels. It's very important when you're operating overseas to remember that U.S., for instance, federal trademark registrations, that doesn't give you any rights overseas. And in fact, in most foreign countries, A, there are no common law trademark rights, and B, the registration process is basically a first-to-file process, where whoever files first is going to get priority rights to those trademark registrations. So it's very important when you're operating overseas, even if you don't have a physical presence, but you're doing a lot of things virtually and otherwise in different foreign countries, to seek those foreign trademark registrations. Unfortunately, the trademark registration process, both in the U.S. at the federal level, even at the state level, because you can register if you're a state organization in just your particular state, and overseas, it's not super simple. It is a bit complex. There usually is some back and forth with the trademark examiner at the U.S. Patent and Trademark Office or other offices, and it generally is strongly advisable to have expert trademark counsel advising you and representing you in that process. We're going to contrast that in a minute to copyright registration, which is a much easier and simpler and more inexpensive process. That being said, this is some of your most valuable intellectual property, some of your most valuable property generally. This is your brand. This is your reputation. This is how people identify your organization in every different way, and as such, you really don't want to be short-sighted when it comes to that. And by the way, I should mention, for domain name registration, similarly, not only for your existing names, but as you're developing new names of products or services or other big initiatives, if you think that you might want to have a website that ties that name into it or something like that, the sooner the better in terms of filing for domain name registrations. That is a very simple, easy process. You don't need an attorney to do it, and I would err on the side of more rather than less. Copyright registration. Now, copyright registration, thankfully, is a lot easier. First off, just like trademarks in the U.S., is it essential? No, it is absolutely not. Back in the day, a number of years ago, before the Federal Copyright Act was amended, copyright registration used to be much more essential in order to protect your rights overall in copyright. That, thankfully, is no longer the case. Copyright rights exist from the moment that some creative original idea is fixed in a tangible medium. And that's a bunch of high-priced legal words that basically means you wrote something on paper, you typed something in your computer, you made a drawing, you took a picture, you made a video, whatever the case may be, you created software. The moment that's fixed on paper, on a computer hard drive, on whatever else, on film, on a video, whatever the case may be, from the moment it's fixed in that tangible medium, copyright rights attach. And you have rights from that moment. And we're going to talk in a minute about some of the more interesting issues about who has those rights and who owns those rights. But those rights are fixed from that first moment. That being said, just like in trademarks, there are notable benefits to registering your copyrights with here at the U.S. Copyright Office, which is part of the Library of Congress here in Washington. It's a very simple process. The fees generally range from $35 to $55 per registration. You can do it yourselves. Your staff can do it. You do not have to have an attorney do it. You might want to have an attorney, help you initially just to get the lay of the land, make sure you get the proper forms, answer your questions. But on a going forward basis, I highly recommend you designate someone on your staff who's going to be responsible for registering your key content. Your articles, your journals, your newsletters, your website, any other things that you may put out that are subject to copyright protection. Those original ideas that are fixed in a tangible medium, which is basically most of the content that your organization creates. You want to be protecting that and registering that with the U.S. Copyright Office. It also has a very important benefit in that if you find some suspected infringement of your copyright, someone is taking your content and kind of passing it off as their own, and you want to send them a cease and desist letter, or you want to get them to stop copying your content. And perhaps it's even, say, a for-profit company that's making a lot of money off it. First off, in order to file a copyright infringement lawsuit against the infringer, you have to have the copyright registered with the U.S. Copyright Office. It's a prerequisite to filing a suit. But even more importantly, if you registered that copyright with that Copyright Office either within the first 3 months of when it was initially published or before that infringement occurs, then of course not only do you have the right to sue and threaten to sue, but you have the ability to obtain what are called statutory damages, as opposed to only being able to recover actual damages. Damages are basically the monetary award that you get if you prevail in a lawsuit. Statutory damages, though, here in this context are statutorily defined amounts that you can recover per infringement. They are vastly, I can tell you from a lot of experience in this area, they're vastly more significant. They're much higher than the amounts of actual damages that you could prove that your organization suffered from the infringement. And even the ability to threaten statutory damages, in my experience, makes a huge difference in the ability to extract a favorable settlement from an infringer without even having to file a lawsuit. In short, there's absolutely no excuse for not registering your copyrights. We also find, by the way, that it's very helpful in convincing, for instance, you see infringing material on Facebook, on Twitter, on LinkedIn, on any other form of social media. The social media operators tend to be much quicker to react and to take down content that you allege is infringing if you have a federal copyright registration for that content. In short, there's absolutely no reason for not doing this, and you want to get in the regular habit of having someone in your staff be charged of registering all of your copyrights, including websites and changes to your website with the Copyright Office. Okay, next, policing use of your intellectual property. So, what we started out so far, we've talked about notices, how to put people on notice that you have protected intellectual property. We talked about registration with the U.S. Patent and Trademark Office, with the U.S. Copyright Office, with state trademark offices, with foreign trademark offices to better enhance your rights. But then once you do that, you also have to take that next step of, we need to make sure that people aren't out there abusing and misusing our intellectual property, that they're not using trademarks to kind of play off of our reputation. We see that all the time in the nonprofit community for purposes of fundraising and many other things. Unfortunately, it does happen by other nonprofits, by for-profits, sometimes intentionally, sometimes unintentionally, but it does happen. We certainly see it with copyrights. The fact that so much content that's put out there these days by your organization and by others is freely available to copy on the web makes a lot of people think that it's freely available to copy without any restrictions. The reality is, as you can probably already guess from what we've talked about, that it's absolutely not the case. The fact that something is out there on a publicly accessible website and that it's able to be copied doesn't give someone the legal right to do so. And if someone does copy your content and is using it on their own website and their own emails and their own newsletters or whatnot, it very well may constitute copyright infringement. There is a very narrow exception for something called fair use. Fair use is an exception to copyright infringement. It is limited to nonprofit organizations, but it's a much narrower exception than most people realize. And it's really based on the type of use and the amount of use, not on the user. The fact that you are a nonprofit organization, even the fact that you're a charity or 501c3 organization, doesn't mean that you can do anything you want with other people's content and it will all constitute fair use and not be subject to copyright infringement. That is simply not the case. It's a complicated analysis that's kind of beyond the scope of the limited time we have today, but it basically says if you're a particular type of nonprofit, like a charity, an educational organization, and you're using a small snippet of someone else's protected copyrightable content for some purpose that furthers your mission, like for instance educating students, and it doesn't cut in any material way into their sales of their protected content, and there's some valid nonprofit purpose for doing so, it may be subject to fair use, but it's a very limited, narrow exception. It doesn't, for instance, give you the right to copy entire news articles on issues relevant to your constituency or your issue or your cause and put it on your website or put it in your newsletters. That's simply not the case. As an aside, one thing I learned early on in this area, kind of a very helpful tool that you should try to instill in all your staff, is that if you see good content out there on other websites, news articles, things like that, white papers, that you think would be relevant to your audience, to your donors, to your constituents, to your funders, whatever the case may be, you can link to that content. And generally speaking, linking, as long as you're linking to publicly accessible pages and you're not bypassing some fees that would otherwise have to be paid, that's okay, and that's generally not going to constitute copyright infringement. Whereas if you copy and paste and put it into your own vehicles, your own website, your own emails, newsletters, etc., that often and generally will constitute copyright infringement. Here, what we're talking about in this slide, though, is you need to go out and police the use of your intellectual property. And thankfully, there are very good, inexpensive services out there that you can contract with. You can hire, search engines and other things like that you can utilize to help police the use of your content and your copyrights, your trademarks, etc. It's very important to do. And then when you find instances of infringement or suspected infringement, you need to do something about it. It doesn't necessarily mean filing a lawsuit. In fact, I've been doing this now for close to 20 years. In the vast, vast majority of cases, for the hundreds and hundreds and hundreds of nonprofits that we've worked with, when we discover instances of trademark and copyright infringement, there very often are cease and desist letters, sometimes coming from the organization, sometimes coming from us as the outside law firm, sometimes a combination of both, like a staged approach. But very, very, very little, almost rarely does it actually turn to pure litigation where you're filing a lawsuit against someone. Sending those quick and direct, but sometimes scary cease and desist letters can go a long way toward resolving the issue. And then there are other mechanisms like mediation and arbitration and just simply settling a matter that generally are effective alternatives. But the key is you need to police the content out there. There's even in the trademark world, there's a concept called naked licensing, which basically means if you let someone else use your trademarks, and it could even be, and we see it a lot in the context of like chapters and affiliates and subsidiary organizations and things like that, or endorsed vendors or things, if you let others use your trademarks and you don't regularly police the use of it, exercise quality control, things like that, put restrictions on use, you can actually jeopardize your trademark rights, and we've unfortunately seen that happen even in the nonprofit community. Okay, let's move on to the next one. Now, codify your licenses from your nonprofit to others in writing. In the copyright and trademark area, I like to remind folks that and we've already done this a lot in today's webinar, it goes both ways. One is you have your intellectual property and you're letting others use it, and when you do that, that's what this slide is about, you need to put restrictions on how that content and those marks and whatnot can be used, both copyrights and trademarks. On the flip side, when your organization is using others' content, trademarks, copyrights, etc., you also need to be sure that you have the rights to do that and you are not inadvertently infringing others' rights, because there can be financial consequences to doing so. And you always have to be looking at both of these things. It really goes both ways. I've seen too many nonprofit organizations that focus. They're really good on one side of that but not good on the other, and you really need to focus on both. Now here, this is another area where my experience has been, for better or for worse, nonprofits tend to be very lax in this area. They let others use their trademarks, their logos, their slogans, their content all of the time without putting restrictions on it. Now, don't get me wrong. Sometimes, and I understand this, I've spent my whole professional life working with nonprofits, oftentimes there is very good reason why you want others to take your content and put it out there, because that advances your mission. It raises awareness about your issues. It does things like that which are very, very important to your organization. That being said, for most nonprofit organizations, after the money you have in the bank and your employees, your most valuable assets are your intellectual property. And so you have to protect this stuff. Otherwise, you run the risk that others will use it and be able to use it in ways that you don't want them to, in ways that might even be counterproductive, in ways that could cut into your revenue streams, in ways that could divert donors or grantors or others away from your organization. And down the road, if you let that happen long enough, you may have no recourse and have nothing you can even do about it. So what you really want to do, and the answer, this is one of those things where I was talking at the outset, there's a lot of simple things you can do to really protect yourself down the road. One of those things is that you always want to get in the habit of any time anyone else outside of your employees are using your intellectual property, you want to put something in writing. It doesn't mean a 10-page signed contract. It doesn't mean a lot of legalese. In fact, I'm a big fan of the opposite, keeping things short, simple, non-threatening, in ways that everyone can understand. But whether it's a volunteer, whether it's a member, a chapter, an affiliate, a sponsor, a certificate, an endorsed vendor, anyone else who is using your intellectual property, your names, your logos, your copyrighted works, put the terms and conditions of that license in writing. A license is a fancy legal word for permission to use. It just means I'm giving you permission to use my content, my trademarks, etc. But you want to put conditions on how they can use it. So, for instance, if it's some vendor who your organization endorses, and in exchange you get a percentage of certain sales, and that's a great arrangement, it raises awareness of your organization, it brings in some revenue, but at the same time, you don't want that company to be able to use your marks in ways that suggest something further or something more than what you're intending. So you always want to put strict limits on how you can do it. You want to get in the habit of having good license forms, kind of stock model documents in place that you can just pull out electronically, tailor to the particular situation, and send it off. For licenses, click and accept features online are as fully enforceable as signed paper documents. That's absolutely not a problem. Keep it as simple as you can. We're going to talk in a slide or two about what are some of the specifics that should go into those licenses. But the bottom line is get it in writing. There are such things as oral licenses and implied licenses. But as I say here in this slide, those can be difficult to interpret, difficult to enforce, very limiting in nature, and otherwise can be problematic. And in short, do not rely on oral or implied licenses if you don't have to. Okay. Sorry for my pauses to drink some water. Okay, number 6, make sure you own or have permission to use all intellectual property. So again, this is kind of the flip side of what we just talked about. This is where you are using other people's intellectual property. This is probably one of the biggest areas of non-compliance and under-compliance that we see in the nonprofit world. And it's difficult because I know you have so many of your staffs who are and or volunteers who are working on putting together content, newsletters, websites, white papers, things like that. And they're going out there and they're doing research and they're pulling things from lots of different sources. And a lot of them have no real understanding of the context, the legal and regulatory context in which all this plays out. What you really need to do as a default rule, as a general baseline rule, is to assume that you have no rights to use anyone else's intellectual property without their permission. Now, the good news is that as a nonprofit, and particularly as a 501c3, charitable, philanthropic, educational, or whatnot nonprofit, and sometimes even other nonprofits like trade and professional associations, generally, most content providers, most owners of, for instance, copyrightable content, will be very allowing and very flexible in allowing you to use their intellectual property if you get proper permission, you ask proper permission up front, and you document that license. Again, it's a license to use in writing. If you ask for that permission up front, it's often very easy to get. Now, let's get back to this issue I talked earlier about. When you have a copyright that's created, I said it's created from the moment it's fixed in that tangible medium, but who owns it? So we're going to do kind of a little aside from this slide to give you this background. It's very, very important. When an organization is an employer, and we're talking about employer-employee relationship, we're not talking about an employer and independent contractors, we're talking about employer to employee. If an employee creates some copyrightable work that's within the scope of his or her employment, then the employer automatically owns the copyright in that work. The employee has absolutely no rights to that work. So one of your employees or you create something, you write an article, you put together a white paper for the organization. Your employer, that nonprofit organization, owns the content. In fact, if you leave the organization and later want to use it, you have to get permission from your prior employer to do that. However, the flip side of that is that anyone who's not an employee of your organization, that rule does not apply. So that rule, by the way, is part of what's called the work made for hire doctrine. It does have a few other applications, although they rarely apply in the nonprofit context. The employer-employer situation is the most common. But what that means is that for non-employees, of course, yes, we're talking about your outside consultants, we're talking about your volunteer speakers, your volunteer authors, but we're even talking about your volunteer officers and directors and committee members. For all of these folks, even if they're doing this, they're creating this at your organization's request and for your organization's benefit. If they are not an employee of the organization, they actually own the rights to what's created. Now, a lot of times in a nonprofit context, you have multiple people and or entities creating things for your organization. In that case, it's what's called a joint work. Joint work means there are joint authors, basically multiple contributors to that copyrightable work. And if you have a joint work, every one of those joint authors has the right to use that work without the permission of the other joint authors in any way that they want. And every joint author has the right to share in the profits that are earned from that joint work by any of the other joint authors. You have to share the profits based on each joint author's proportional contribution. That can be a nightmare situation for nonprofits, and we've seen it happen, unfortunately. So you might have, for instance, a joint work, and maybe, say, a video that's being created for your organization. You hire an outside videographer to work on it, but then you also have your employees working on it, and then maybe you also have some volunteer leaders who are involved. All of those folks, for the employees, of course, those rights are owned by your employer, by the nonprofit organization, but all of the rest are owned either by those individuals or their employers if they're doing work within the scope of their employment. And in that situation, if your nonprofit organization wants to secure the rights to that work, which I highly recommend you do, then you need to be sure at the outset, it's always easier at the outset than later on, to get those individuals to transfer their rights over to you. Now, we've been talking so far about a license, which is permission to use, and we're talking about copyright licenses specifically. There, of course, are trademark licenses as well, which is also permission to use. In the copyright area, though, there are really two different vehicles that we use for nonprofits to be able to use someone else's content. One is a license, and we'll talk about later the different types and scope and specifics of how those licenses can be structured. The other is called an assignment. An assignment is a complete transfer of ownership. Now, sometimes you will be able to get an assignment from your volunteers, from your speakers, from your authors. They're writing an article for your newsletter. They may have no problem transferring ownership to your organization. A lot of times they won't. For instance, I do a lot of writing of legal articles on nonprofit legal topics and get them, they get published. I get asked to have them published by lots of different publications and whatnot. I never transfer copyright ownership. I want to maintain ownership. I will give them a broad, non-exclusive license to use that work in any way they want. They never have to come back for permission. They never have to pay me a royalty or fee. But I want to maintain copyright ownership. Contrast that to a situation where you are paying, say, a software developer or a photographer or a videographer to create something for your organization. Often when you're paying someone to do that, while the payment of money gives you absolutely no rights other than maybe some sort of an implied license, it certainly doesn't give you ownership. But when you are paying for something, you're generally in a much better leverage point to be able to demand transfer of ownership, to ask for it. So in that contract that you enter into, that has lots of other provisions. What are the deliverables? How are you going to pay them? When does the contract end? How can you terminate, et cetera? In addition, you want to put in there a copyright assignment provision that says they hereby transfer ownership of the copyright of what they're creating to you. And just so you know, assignments of copyright have to be in writing to be valid. There is no such thing as an implied or oral assignment. And even exclusive licenses, so you can have exclusive or non-exclusive licenses. An exclusive license means you're the only one that's going to have permission to use this work, at least for a particular period of time or in a particular geographic area or market or whatnot. But any sort of exclusive license also has to be in writing to be valid. But as I said here, you really want to get in the habit of codifying all licenses, even non-exclusive ones, in writing. Now, some of the details here, if you look at the last bullet point, for both written copyright and trademark licenses, here's some of the buzzwords that you want to put in there. And ideally, if you're the nonprofit seeking a license from someone else, you want to make it as broad and kind of bulletproof as you can. So you want to make it irrevocable, perpetual, worldwide, meaning you can use it anywhere around the world, and royalty-free, assuming you're not paying for it. You also want to specify whether it's exclusive or non-exclusive, or perhaps it's exclusive for a period of time, or in a particular market or a geographic area, or else otherwise. You want to make sure it covers all current and potential future uses of the work in all media. You want to make it as broad as you possibly can. For instance, if you get a copyright license from an author who's writing an article for your newsletter or your magazine or journal, but you know or think that you may want to use that later as a handout in a conference you're putting on, in some compilation that you're doing on your website, in some white paper, whatever the case may be, you want to make sure you have the rights to do that, and so you specify that up front. Also make sure you have a release to use the author or speaker's name, photograph, etc. That may or may not be relevant, but the right to use someone's name and likeness is a separate right. It's part of the right of privacy. It's completely separate from copyright, but you want to make sure you use that written document to get that in there. And then when we say representations and warranties, again, these are kind of fancy legal terms, but what they basically mean is the author, the speaker, is representing to you that it's his or her own original work, he didn't infringe anyone else's rights, he didn't use it without permission, also that it doesn't defame anyone, it doesn't violate anyone's right of privacy, other things like that. Those are all the sort of things you want to put in there. We're going to skim through a couple of these because they're a bit duplicative. We're kind of drilling down now into more specific types of agreements. So with your independent contractors, these are your software developers, your consultants, photographers, lobbyists, other contractors. As I said before, try to get ownership if you can, or if for some reason you can't, for instance, a lot of times in software, the software developer will give you an assignment of certain parts of the work, but they won't give you an assignment of the underlying software code that is kind of the bread and butter of his or her business, but you can generally get at least a sufficiently broad license to that code to be able to use and modify the works in any way you can. One of the right of copyright has actually a number of different sub-rights subsumed in it, It's the right to use, it's the right to distribute, to sell, to create, for instance, a movie or a play out of it, but it also includes the right to create derivative works, meaning like a subsequent edition or version or things like that. And so you want to make sure you have all of those rights. As I said earlier, the basic rule in copyright law is the person who creates it is the one who owns it, regardless of who paid for it. We talked about the exception for employee issues, where if it's within the scope of the employment, the employer automatically owns the rights. And then I talked a bit about joint authors, which is, again, a very common situation in the nonprofit world. Even when there's not outside consultants or contractors involved, even the confluence of employees and volunteers working together is very important, for instance, to get your volunteer leaders, anyone who's creating copyrightable content, even committee members, to sign a simple one-paragraph, non-threatening little form that assigns the copyright to their contributions over to your organization. Very simple to do. We have some great, easy-to-use forms that are very non-threatening and easy to understand. And I recommend, by the way, using that same sort of simple, be very frank and upfront and clear about what you're asking them and what you're not asking them to provide for your authors and speakers and things like that. I recommend that same approach, which leads us to this slide. Make sure it's sufficiently broad. I remember even back in the early years of practicing law, for some clients I would write, I developed a form, kind of cover letter that accompanied, or in these days cover email, that would accompany the license form and says, this is what this is, here's what we're asking you to give us permission to use this work in any way that we need to without your subsequent permission and without having to pay your royalties. But we're not asking you to give up your rights. We're not in any way limiting your rights. You can do whatever you want with it. Sometimes, for instance, if it's an article you're publishing in your magazine, you may want to get an exclusive right that they agree not to get it published in any other place or even on their own website for a period of 3 months or 6 months or something like that. But beyond that, you work out the terms of that. And remember, too, for speakers, it's PowerPoint presentations, which many speakers use. You want to get the rights to those, and also the right if you're making an audio or visual recording. For instance, today there's a PowerPoint that I provided to GuideStar. There's an audio recording being made at this webinar, and they do a good job of capturing those rights so that they then have the right to use that recording and that PowerPoint in any way that they want in the future. Again, it's a duplicate of what we just talked about: officers, directors, committee members, even other volunteers. Anyone who's creating copyrightable content, don't go crazy about it. Just because someone's a volunteer doesn't mean they're creating copyrightable content. But where they are, it's very important to do that. And as I say in the second bullet point, it's very common to use that same form to also throw in some other important things. For instance, for officers and directors, imposing confidentiality and non-disclosure obligations on them, to require them to disclose particular conflicts of interest that may arise, and to put any other restrictions or guidelines on their service. Number 10, for those of your organizations who are membership organizations, I said in the beginning that copyright law protects original expressions of ideas. What it does not what does not protect is mere facts. So a mere fact, or in this particular example, we're talking about, say, alphabetized listings of members or donors or whatnot of your organization with names, addresses, email addresses, phone numbers, etc. If it's just an alphabetized list of that sort of contact information, that's not protected by copyright law. And the U.S. Supreme Court has dealt with a few cases over the years that have made that very clear. There's no copyright protection for that, because there's not the minimum level of originality and creativity required to be subject to copyright protection. By the way, it's the same reason that you could have the most valuable white paper or document that you put together that has all this critically important information and facts and data and tables that you spent years and hundreds of thousands of dollars researching and putting together. That copyright law only prevents someone else from basically kind of cutting and pasting chunks of that or the entire thing and using it for their own purposes. It does not prevent someone, copyright law does not prevent someone from taking those underlying facts and kind of shuffling them up and spitting them back out in some other format, in some other creative, original way. There's no copyright protection for that. So that's why you need to rely on other legal mechanisms to protect that. In that example I just gave, that if you really protect that information and you only provide it to people who pay for it and under a strict license agreement, for instance, it may be considered a trade secret that's subject to trade secret protection and other form of intellectual property. That often, though, doesn't apply in the nonprofit context. So the easiest way to protect that sort of stuff is contractually. And again, I don't mean a 10-page signed contract. I just mean some sort of a, what the software industry used to call a shrink wrap license, basically some click and accept feature where the user says, by viewing or using or getting access to this information, I am agreeing to only use it in a particular way. For instance, only for my own benefit. I agree not to sell it or license it or share it with anyone else, or whatever the case may be. And you want to contractually obligate them, even if it's a click and accept feature on your, through your online mechanism. You want to do that and then keep a record of that to impose a sort of contractual obligations on the end user. And then finally, at least the last slide here, rules for interactive online services. Many nonprofits operate various forms of listservs and chat rooms and other sort of interactive online services where your constituency, your members, your donors, your supporters, or others can communicate with you and amongst themselves often. And you're kind of hosting that vehicle. Or you may have a sponsored site on your organization's page on Facebook or whatnot, or other social media where you're facilitating those conversations through that site. It's very important in this area to have rules for what people can say and post and not say and not post on that site. Obviously here the focus of today's discussion is copyrights and trademarks. You want to make sure that people are not posting copyright infringing material, that they're not posting trademark infringing marks and things like that. But you also want to throw in other rules, like for instance to protect yourself from defamation liability, that they're not posting negative, untrue comments about other individuals or companies or organizations, etc. You want to prohibit them from using the online forum to promote their own products or services, things like that. And have a good takedown policy in place to make sure that you immediately remove or have removed, if someone else is controlling it, any material that might violate those rules. And I always advise clients to err on the side of, if you're not sure, take it down, or ask the social media site to take it down. Error in the site, you can always do your due diligence and put something back up later, but it's important to do that. I didn't mention it earlier, but there are two federal laws that help protect nonprofits in the area where third parties, meaning not your organization or its employees, but outside parties, are posting things on some sort of a site that you control that end up infringing someone else's copyrights or violating someone else's rights through defamation or whatnot. The Digital Millennium Copyright Act is a law that says if you designate someone to be an agent for purposes of receiving notice of potential infringing material that's on your website, for instance, and you have to file notice of that with the U.S. Copyright Office, who that agent is, and you have a written takedown policy and you enforce that policy, then that law provides a great, very high degree of protection to be sure that your organization will not be held liable for contributory copyright infringement in the event there was actually infringing material. And on other things like listservs, there's something called the Communications Decency Act. Section 230 of that law provides protection from defamation liability and certain other liability where third parties are posting defamatory content on your controlled online services. And then finally, before we get to questions, one other thing I did want to mention is insurance coverage. This is an area that is very important for your organizations to focus on, because despite the fact that you might do all of these things we've talked about here and do a great job at doing them, you can never stop someone from suing you. And it happens all the time in the nonprofit community. And while most lawsuits settle or get dismissed, they can still be very expensive to have to defend. And so having good insurance coverage in this area for copyright and trademark infringement can go a long way toward protecting your organization's bottom line. The problem is that unlike certain other forms of insurance, like commercial general liability insurance that helps protect, against slip and fall accidents and tort liability arising from those, or even employment practices coverage, which provides protection for employment-related claims, The copyright and trademark infringement coverage really varies wildly from insurance carrier to carrier. It's typically contained in your directors and officers liability insurance policy or some other form of errors and omissions liability insurance. But the coverage really varies significantly from carrier to carrier. Some of them are pretty good. Some are very narrow. Some have some very narrow definitions or very broad exceptions. And so it's really important to pay attention to your insurance coverage to make sure you're properly protected. So with that, I'm going to turn it over to Cody. Cody, we'll take some questions, and we can go certainly a few minutes over if we have a lot of questions.
Sure. So just starting from the top, it sounds like a lot of these issues that an organization might face in terms of policing their own collateral and trademarks can be handled by a simple cease and desist letter, like you said. Is this something that a nonprofit could handle on their own, or would you recommend that they get some legal advice before doing that?
It's a great question. Two things. First off, you don't even get to that point if you don't know about the infringement. And that's one of the big problems I find with nonprofits is they're not doing the policing that's necessary. And like I said earlier, you can hire companies on a very cost-effective basis to do this for you, searching your content, your keywords and marks and things like that. But when you do find the infringement, yes, I am generally a fan, probably 99% of the time, of having the organization send the first cease and desist letter or email or even phone call or whatever the case may be. I'm a fan of kind of having multiple levels to be able to turn to. Plus, with a nonprofit doing the initial outreach, it tends to be a bit of a softer face. And most of the time, honestly, most of the time, you're going to get the reaction that you want. If it doesn't work for whatever reason, then at least you have the ability to step it up a notch and bring in your lawyer, whether it's in-house or outside lawyer, to send a more threatening letter. And again, that often gets people's attention more often than not.
Great. And so we have a question from someone that they discovered another organization was using their logo some time ago, but that organization's mission was so different and their name was so different that they didn't think it was a problem, and they expressly told them they had permission. Now they're finding another organization that's using the logo, but they're much closer in mission, and they're concerned about that. So it's kind of a cautionary tale possibly. Does their previous grant of permission hurt their chance of going after this organization that they're more concerned about?
It's a great question, especially because it raises a point that I probably should have talked about in the beginning, and that is that trademark law, it's brand protection that identifies the source of a product or service. By extension, you can probably think, if you think this through, the same mark, say it's the name of an organization, it only provides protection for an organization that is providing the same or a similar product or service. So, for instance, I don't even know if this bank still exists, but I remember one day I was heading down the streets in Washington, D.C., heading toward a restaurant in the Georgetown part of D.C. called Sequoia Restaurant. And I was driving down M Street, and I saw a bank, a local bank called Sequoia Bank. Literally, the two were probably 10 blocks away. But the reality is that there's no trademark infringement there because they're in completely different lines of business. One's a restaurant and one's a bank, and they're not competing against each other. And so with one exception, and that is if you have a mark that rises to the level of what's called a famous mark, the brand names that you would all recognize, Nike, Coca-Cola, things like that. If you get to that level, then you can actually prevent anyone from using the same or a similar mark because it has a substantial likelihood of being confusing. But in the nonprofit world, most organizations' marks are not famous marks. There arguably are some, like the American Red Cross or AARP or some that do rise to that level. Most are not. And so if there is another organization in a very different field that's using the same or similar name, that's probably acceptable, and frankly, from an enforcement perspective, there actually may be nothing your organization could do about it, even if you wanted to. Of course, if they come to you and ask for permission, and you want to give permission, put it in writing, but put limits on it, and say, this license permission to use the mark is conditioned on the fact that you're in a completely different line of business. In the person's question that you read to me, Cody, there, it sounds like there's another organization who's not in such a different line of business, in a much more related field. The fact that permission was given to the unrelated organization, and now this kind of more closely related organization is trying to use the same mark. No, that does not at all jeopardize their rights to enforce their trademark rights. against the new organization that's come along. But it's also a great example of how if the underlying organization has a federal trademark registration for that mark, I can tell you from a lot of experience it's a lot more effective in bringing that cease and desist action. And if you have to go battle them for domain name registrations, or if you even have to battle them in court over the trademark infringement itself, you're in a much better position if you have the federal registration.
Great, great. And I see that we're just a minute or two over the hour, so we'll answer just a couple more questions. Jeff, you did a great job reading the minds of some of these questions, so folks that are still with us, I hope you were able to get your answer heard from Jeff. If you didn't hear it or you'd like to go back, I just want to remind you that we'll be sending a recording within 24 to 48 hours for you to go back and pick up all those details. But just a couple more questions. Can an affiliated 501c3 and a tax-exempt organization use the same trademark since they're affiliated?
So I'm guessing, I don't know if we're talking about two C3s or related C3 and C4. It really doesn't matter for these purposes. It definitely matters. There's a lot of other issues that come into play in that world and the tax exemption side. But from a trademark perspective, one thing that we find in these situations, and we have, in fact, I'm dealing with some right now, some nasty disputes between two affiliated organizations, kind of sister organizations. We don't call them subsidiaries because subsidiary means there's an owner, and with nonprofits, by definition, there's no stock, there's no owner of the nonprofit. So it's an affiliated entity, usually with some control mechanism, where usually one entity is kind of the more dominant entity that kind of functions like a parent entity that exercises a lot of control over the other. But sometimes these organizations split off. Sometimes they have very different boards of directors and they end up going in different directions and they get into some nasty disputes. Like I said, we're involved in 2 or 3 of them, I think, right now. In those situations, one of the most important issues in those disputes is who owns the trademarks, namely the name of the organization, which often is one of the most important and most valuable rights of the organization. And so ideally, when you're structuring this from the outset, you want to be very clear who is the parent entity and make sure that those trademark rights are clear, the ownership is clearly vested in that organization. So the federal trademark registrations, for instance, are registered in the name of that dominant entity. And then if you have an affiliate who's going to use that name as part of its own name, which is very common, happens all the time in the nonprofit community, particularly for an affiliated C3 and C4 organization or an affiliated C6 and C3 organization, you want to have as part of that affiliation agreement between the two a license agreement. Not surprised, I'm sure you're not surprised based on everything I've said. And I remember one of the first affiliation agreements I ever drafted, I think it was between a related 501c6 and C3 organization. It provided a license for the C3 to use the C6's name for so long as they were affiliated and under certain conditions and having to get certain permission and with certain quality control rights being exercised, all the things that you should have in every license agreement. And this is really no different. But where it can get sticky is if no one has any federal trademark registration and they're both using the rights, they're probably both developing common law rights over the years, then if there's a split or a threatened split down the road, it may be that that entity you thought was the dominant entity or was the dominant entity really doesn't have the right to stop the affiliated entity from using that name, and that can be a big problem.
Great. And so one kind of closing question for organizations that are going to go out and try to police use. We have a question from an organization that's run into trouble in other countries with their names in terms of trademarks and products. In the U.S., though, they're fine. So they're kind of in this balance of using language in the U.S. that's different from what they use in other countries, and they're finding that the public is getting very confused and is not using it correctly. So I guess the heart of the question is, who is the focus on? Is it how everyone is using it incorrectly, or if the organization is very clear and holding that line, are they okay?
I'm not sure I fully understand the question, but I think the important takeaway from this is that trademark rights in today's world, even though you have things like the web, which don't really know any geographic boundaries, trademark rights are still very country specific. And your trademark rights in the U.S. are defined by federal laws like the Federal Lanham Act and things like that. and your trademark rights in Europe or in China or in India or elsewhere around the world are governed by the laws of those countries. And yes, having, for instance, a federal trademark registration can sometimes be helpful in certain countries in order to secure registration in those countries, but you still have to comply with those laws, and those laws in some cases are very different. The trademark laws and the constructs and the requirements are very different than they are here. And so you have to be cognizant of that if you want to have trademark rights in those foreign countries. And don't forget what I said earlier, that first-to-file regime that exists in most foreign countries and the absence of any common law rights means you really need to rush to file in countries that you are operating in. And unfortunately, it's expensive. We have some clients that we have helped pursue trademark registrations in 250 countries around the world, often working with local counsel in those countries. As you can imagine, this is not an inexpensive process, but for a global organization or even for an organization that's heavily invested and active in a particular country or a series of countries, it's a very, very important step to protect your investment.
Excellent, excellent. Thanks, Jeff. This was really excellent. I know I speak for everyone in attendance today, and thanks everyone for joining us today. I hope you found this as informative as I did. We covered a lot, so as I mentioned before, you'll receive an email within 48 hours with a link to the recording of today's event to refer back to as needed, as well as to view Jeff's slides, which had some excellent information as well.
And Cody, if I could just add too, for those of you who want more information on these topics, as you can see in this slide, we have tons of articles and PowerPoint presentations, but those recorded webinars, which we've been doing for about 5 years now every month, we have several that have been devoted to copyright and trademark issues and social media, legal issues. There's some really interesting recorded webinars on these topics that I'd encourage you to listen to if you want more information.
Absolutely, and I know you can't click on the slides right here within WebEx, so these links will be included in your follow-up email as well to access these resources Jeff just mentioned. So thanks everyone, and in the meantime, feel free to reach out to myself with questions about GuideStar at webinars at guidestar.org, or Jeff, you see his contact information here. Thanks again for joining us, everyone, and have a great rest of your day.